Hello, everyone. This is Tom Fox back for our concluding episode in our five-part series on the Hughes Hubbard 2024 FCPA alert. Today, I'm absolutely thrilled to have with me Sam Salyer. Sam, first of all, welcome to the podcast.
Thanks, Tom. Thanks for having me on.
So, Sam, we're going to dive into really something we maybe should have started with, but we're going to end with a bang by some of the highlights. And we had some really interesting highlights in 2024. A lot of people have commented upon the dearth of FCPA enforcement actions, but what I found is when you have a smaller number, it increases their importance. So with that introduction, what do you see as, or what did the alert see as some of the key highlights?
Maybe you mentioned a smaller number of corporate enforcements, but there were also 4 FCPA trials of individuals that took place this year, which was the most that the FCPA units ever conducted in a single year. While there were a few less corporate enforcements than we've seen in prior years, I do think there was still a lot of activity. In particular, we saw the end of the Myrta case, which is a fascinating, long-running case where a Swiss financial manager who the DOJ alleged had assisted PDVSA officials in laundering money that was the proceeds of bribes. This individual had been extradited to the U.S., had fought and had his case dismissed multiple times, and then had the dismissal overturned by the Fifth Circuit and remanded back, eventually resolved this year by pleading guilty and sort of putting into that long-running but very interesting set of legal proceedings. There was also the Aguilar trial. This is an individual, a former VTOL commodities trader who was charged by the DOJ with conduct involving both Pemex, the Mexican oil company, and Petroecuador, and had successfully severed the Pemex allegations, FCPA charges, and to a separate proceeding in Texas, but went ahead and went to trial in New York on money laundering charges and on FCPA charges related to the Petroecuador scheme, and was eventually found guilty and then reached a plea agreement to plead to the remaining charges and transfer those up to New York. As you said, there were a few smaller number of corporate enforcements, but there was still a lot of activity this year.
Sam, let me pick up or explore that point a little bit because I found it incredibly interesting that after multiple years of either no or low individual enforcement actions, and even when they had them, they typically were plea agreements. We had 4 go to trial. We had another one with Trafigura and Petrobras. Were they more willing to roll the dice? Did they think there were some structural components of the FCPA the DOJ had misinterpreted or interpreted incorrectly so that they had a real chance? Or was it just plain old arrogance?
I think every individual, it's hard to put yourself in the head of defendants. I mean, it's a different calculus when it's your freedom or your liberty on the line. So I think everybody has a different risk tolerance. I've represented individuals who they really want their day in court. They feel like they've been mistreated and they want to have a chance to stand before a jury of their peers and see them decide the case rather than attorneys in Washington. I'm not sure I would tie it to any particular policy reasons or structural concerns or issues with the FCPA. Although when we do have the individual trials, a lot of times those are the issues. That's when these issues are actually litigated. So it's very interesting to see some of the developments play out in a courtroom rather than simply through DOJ interpretations.
What are some of the other highlights that you found were particularly prescient in 2024?
Sure. One that maybe I think the law firm audience might be very interested in the corporate enforcement actions for internal compliance professionals. The updates to the ECCP might be even more important, and that's the DOJ's evaluation of corporate compliance programs. This is the guidance that DOJ uses not only in FCPA cases, but in other corporate enforcement actions to evaluate how effective a corporate compliance program is. And this was updated, not totally earth-shattering changes, but there was a lot more of a focus on emerging risks and the use of emerging technology. We have the term AI is defined now in the ECCP. And this is signaling expectation from the DOJ that within companies, compliance officers are both thinking about how new technology is going to impact their business and impact the compliance risks that they're facing, and that compliance officers and compliance departments have access to new technology, and that they're using this technology both in assessing risks and addressing them, and also in evaluating how well their compliance program is functioning. So that's maybe another highlight this year is we're seeing once again, the DOJ is giving the expectation that technology is being used in the design and the evaluation of compliance programs.
The DOJ also had some other, I don't know if you would call it a pronouncement, policies or programs around whistleblowers and clawbacks and holdbacks. Could you tell us a little bit about those?
Sure. I think probably most significant this year, the whistleblower program, and this sort of DOJ officials have talked about this as kind of filling in the gaps where the SEC has long had a whistleblower program. There's been a lot of commentary and a lot of information released about the sometimes staggeringly large awards that they've given to individual whistleblowers at following large corporate resolutions. However, the SEC's program only applies to issuers. And so from the DOJ's perception, there was this gap where companies that were subject to the FCPA, but were not issuers or were not U.S. companies, there may not have been an avenue for whistleblowers to obtain an award if they wanted to make a report to the U.S. government. And so the DOJ's new whistleblower program kind of in their vision fills in that gap. And I think where this probably, we could talk all day about the impacts that these sorts of programs have on behavior. But from a corporate inside compliance officer's perspective, I think the most significant feature of the growing prevalence of these programs is that if you get a whistleblower report, if it comes to your desk, you should expect that it's on somebody's desk at the DOJ as well, or the SEC, because the incentives are there for whistleblowers to make these reports. And, as I mentioned earlier, the potential individual rewards are it's generational wealth that we're talking about. I think that's kind of the takeaway for me, is that these all the incentives are in place for anybody who's inclined to blow the whistle to make that report to the government as well as to their compliance department.
What I try to communicate around that issue is that it puts even more pressure on corporate compliance programs and corporate compliance officers to quickly and efficiently assess any information that comes in through a triage process and either do a very quick internal investigation or hopefully pick up the phone and call someone like you. Is that a message that you're either hearing or you're actually having conversations with clients about the need for what the DOJ says, the need for speed?
Yeah, no, I think that's exactly right. The time that folks sitting in-house have to respond to whistleblower reports, I think, has decreased. And just because, as I said, you kind of have to expect that information is sitting with somebody at DOJ and they're waiting to see how you're going to respond. Are you going to come in and report to them? And so there's a need to quickly evaluate whether this is real, what significance this information has, and make a quick decision about whether it's in the company's interest to self-report.
There were several cases listed around traders. I come out of the energy industry, and in the first decade of this century, there was a sweep of FCPA cases through the energy space. And what I think we've seen over the past 18 months, and including in 2024, was a sweep of cases in trading. It could be energy trading, it could be commodities trading. If you've seen that same thing, how would you advise a trading company, or what would you advise them to do now? Are they on the radar? Does the DOJ have the magic key to understanding traders and how they may have violated the FCPA? What would you assess around these series of cases around traders?
Yeah, no, I think you're spot on. I mean, I think with the Gunvor case, with the Trafigura case this year, that I think is continuation of in 2022, the Glencore case and Vitol before that. So I agree. We've seen this sort of, I know the DOJ folks don't like to acknowledge that there's this industry specific focus, and I take them at their word. There probably isn't an intent to target a particular industry. But once you start investigating one company, you start to understand how the industry works. You start to get prosecutors who are experienced in conducting these sorts of investigations. And when they start to talk to one company, you could very well understand that they'll hear from someone, all of our competitors do this as well. Here's how they do it. Here's how they do it. So I think these investigations generate tips and generate new investigations. In terms of what, other companies in the industry, I think, being aware that there's attention being paid to this industry, that you have prosecutors within the FCPA unit who've looked at a lot of similar cases, who understand very well how the industry works and where the risks are. But I don't think there needs to be any dramatic difference in how you approach assessing your compliance risk, but being aware that there is this attention and that these cases are ongoing.
One of the highlights in the alert was the individual prosecutions against former Glencore traders in the United Kingdom. So I was wondering if you could say a few words about the SFO, which had certainly a tumultuous year, but them bringing individual prosecutions and how that might tie into some of the things you saw with the individual prosecutions from the Department of Justice around individuals for FCPA violations.
Yeah, I think you used the word tumultuous, which I think is fair. I think this is something that the DOJ has certainly talked about for a long time, that the focus is not only on the big dollar figure corporate resolutions. The focus is identifying culpable individuals and bringing those cases. I think it's potentially a risky strategy for the SFO, because as we talked about sort of at the beginning, individuals are potentially a little more inclined to fight and fight hard when they're facing criminal charges. But I think it's also a way for the SFO to sort of get to its mandate to identify and prosecute corporate crime. And again, we'll have plenty of opportunity to talk about these cases. They've set a trial date for June 2027. So we've got years of speculation about the SFO ahead of us.
Sam, I wanted to end by asking you if you could say a few words about, let me get the name of this legislation correct, the Foreign Extortion Prevention Act. I just call it FEPA. Its passage and being signed into law last year, and then what you saw about it this year.
Yeah, there's a lot of ways that you could come at this. I think this is another one of these topics that, we could have a really long conversation about. This is when the FCPA was passed, intentionally, the law was drafted not to criminalize the act by a foreign government official of soliciting or accepting a bribe, with the intent that the purpose of that was that the FCPA was meant to be a law to go after corporate crime, not to target foreign government officials, and that there were all sorts of geopolitical implications that could bring that at the time was not the intent of the law. Obviously, now that's changed. This was a bipartisan bill. And it, I think, signals that there is the potential willingness to hold foreign officials to account for participation in these schemes. I think there's all sorts of, as I said, sort of geopolitical issues that this could raise. You could sort of see this being used in a targeted way, or you could see it just becoming sort of another piece of a lot of the typical FCPA prosecutions that we've seen over the last few years. But I think this law was passed and then amended about 3 months later. So I do think there's a lot of people who are kind of laser focused on how the wording of the law, what standards are being put into place, and how this is going to affect existing and future bribery prosecutions. I think there's a lot of different directions that this law could go or could be taken. And I think we kind of have to sit back and see what the appetite is of the prosecutors, where they're going to target their resources and what cases they're going to bring.
Sam, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if our listeners wanted to access the alert or perhaps sign up for a bound copy, what might be the best place for them to go?
Sure. You can check out the firm's website at hugheshubbard.com, and you'll be able to either sign up to receive an electronic version, or if you're an ink and paper person, we'll send you one.
Sam, I wanted to thank you again for taking the time to visit with me, and I hope we can continue this conversation.
Thank you very much. It was nice to talk to you.
All right.
All right. Thank you.